owns the copyright to content generated by artificial intelligence? With the proliferation of AI systems that generate text, images, music, and even video in recent years, this question has become one of the most debated topics in the legal world. Let's think about. You can create a novel, a piece of music, or a painting by writing a few lines of code for artificial intelligence. In this case, who is the real owner of the resulting work? The person who wrote the command? Or the company that developed the artificial intelligence? Or no one? Traditional copyright laws have been based on the principle that the author must be human for centuries. However, the fact that machines can now produce products that can be considered creative has begun to challenge this fundamental assumption. The Thaler versus Perlmutter case, which took place in the United States and caused a stir in the legal world, is similar to the topic we are discussing. The case involved a visual art piece titled A Recent Entrance to Paradise, created entirely autonomously by an artificial intelligence system called the Creativity Machine, developed by computer scientist Dr. Stephen Thaler. When Thaler applied to register the work with the U.S. Copyright Office, he listed the machine's name as the author and his own name as the claimant, specifically mentioning that the work was created by a machine without human intervention. However, the U.S. Copyright Office, and subsequently, the court ruled that copyright could not be granted to a work without human contribution. The main reasoning behind the decision was that copyright law exists to protect things made by humans, and a machine, no matter how creative the artificial intelligence may be, cannot be legally considered a human. The European Union also takes a similar approach. The EU's current copyright regulations also require that a work be created by human hands. Therefore, an artificial intelligence system cannot be the sole author of a work. The decision posed the question: at what level is human intervention considered sufficient? However, isn't the person who commands artificial intelligence to create this work, who gives commands to produce text or images, truly creative? For example, a designer who spends hours trying to find the right command to obtain an artistic image is actually using their own imagination, isn't he? Some people argue that for this very reason, the person who writes the command should at least be recognized as a co-author or co-artist. Some legal experts propose the creation of a new category of rights, known as sui generis, independent of existing copyright laws. As a result, artificial intelligence cannot currently be a direct artist. This is a highly controversial topic. Don't forget to share your thoughts in the comments.